Be ready. Start. We have heard the learned counsel for the parties. Learned counsel for the appellant had argued that the appellant had no premeditated mind to kill the deceased wife and that he had no intention even to kill her. Therefore, the provisions of Section 302 of IPC are not applicable, and at best, he can be charged under Section 304 of IPC. The above submission has been strongly opposed on the ground that the appellant had burnt the deceased wife with a matchstick, fully knowing that she was drenched in kerosene oil, and that lighting of matchstick and throwing it upon her would certainly cause her death. In the case at hand, admittedly, there are multiple dying declarations on record. The first dying declaration is in the form of the statement. This statement of the deceased wife before her death was made before the judicial first class magistrate Ernakulam. The sad statement clearly reveals the cause and circumstances of the death of the deceased wife. The other statement, which can be read as a dying declaration, is P10 recorded by the head constable at General Hospital, Ernakulam, wherein also the deceased wife repeated the same narration as in P1 in relation to the incident of her death. Both the above statements, if read together, would reveal that on the fateful day, the appellant had assaulted the deceased wife under the influence of alcohol. He even struck a blow on her chest and pushed her. At the time of the sad incident, the children were playing in the country yard. When the assault of the appellant became unbearable, she took the can of kerosene from kitchen and poured it on her body, whereupon her husband lighted a matchstick and burnt her. The magistrate before whom one of the dying declarations was recorded proves the correctness of the statement and that when the statement of the deceased was recorded, she was coherent and oriented. He also accepted that there was no reason for him to believe that the deceased was not in a position to make the statement or that the statement made by her stands vitiated for any reason. The statement of PW5 was supported by that of PW14. The statement of the deceased wife further categorically states that the appellant was in habit of drinking alcohol and used to assault her frequently in an inebriated condition. She also stated that various criminal cases are pending against the appellant in connection with similar kind of assaults. The above aspect, as stated by the deceased, was corroborated by the testimony of PW21,